Hello, and welcome to the League of Women Voters Candidate Forum for a Magisterial Judge for the municipalities of Aspinwall, Blawnox, Fox Chapel, O'Hara, and Sharpsburg. My name is Chris Berger, and I'm a Vice President of the League of Women Voters of Greater Pittsburgh, and I will be your moderator for this event. The League of Women Voters is a nonpartisan organization that neither supports nor opposes any candidate or political party. Rather, we are dedicated to facilitating the informed and active participation of citizens in government. The forum is being conducted via teleconference and will be streamed in its entirety on the League's Facebook page on Tuesday, October 19th at 8 p.m. and thereafter posted on our YouTube page. To access both our Facebook and YouTube pages, click on the symbol at the bottom left of every page on our website, lwvpgh.org. The magisterial judge represents the first rung in Pennsylvania's legal system and is responsible for dealing with a variety of offenses, ranging from traffic violations, disorderly conduct, truancy, drug possession, theft, landlord-tenant disputes, to more serious issues like setting bail, granting protection from abuse orders, issuing arrest and search warrants, in addition to performing marriages. Magisterial judges serve a 6-year term and must run for re-election. Now, a few specifics regarding the forum this evening. We are going to have about 60 minutes to ask questions, and each candidate will give a closing statement. Straws were drawn earlier by the League of Women Voters Committee to determine the order in which the candidates will speak. Each candidate will have a chance to answer each question, with each person having 1 1/2 minutes to respond. There will be no time for rebuttals. If a candidate wishes to respond to another candidate's statements, he or she will have to use the time from the answer to their next question. I will be asking the questions in a rotating manner so that each candidate will have equal chance to be the first to answer a question. Questions have been gathered from a variety of sources from the public and from League members and have been reviewed for relevance to the position being sought, duplication, clarity, and civility. Candidates will be timed and candidates will be advised when their time has been expired. Although if you're in the middle of a sentence, you may complete it. Please remember that these candidates are your friends and your neighbors who have stepped up to serve your community. It's my honor now to introduce the candidates for tonight's forum. For the independent candidate, we have Jen Ivashevic, Dave Turner, the Republican candidate, and Matt Rudsky is the Democratic candidate on the ballot. The first question this evening will go to Ms. Ivashevic. What are your qualifications for being a magisterial judge, and why are you running for this position?
Okay, thank you to the League for hosting this forum. This is a wonderful thing you're doing. My name is Jen Ivashevic. I have been an actively practicing attorney for almost 22 years. I started my career in the Allegheny County District Attorney's Office, where I worked for 13 years. And I was assigned to work in Judge Lang's courtroom in our community as the Assistant District Attorney for 6 years as an area prosecutor. I've been in private practice now for almost 8 years, and I devote a portion of my practice to handling pro bono cases, and because I think that's important to do. I've handled well over 50,000 cases in magisterial district courts throughout the county and surrounding counties. I'm an Aspinwall resident. I've lived here for over 20 years, and I'm very active in the community. I volunteer for local nonprofit organizations, and I try to give back to my community at every moment. I am running for this position because I know that I'm the best person for this office. I have spent my entire career helping people, and this, along with my passion for the law and justice and my love for the community that I live in, is important to me, and it's a way for me to continue to help residents of our district in a more wide-reaching capacity.
Thank you. And same question to you, Mr. Turner.
Thank you. My name is Dave Turner. I'd also like to thank the League for hosting this event. I bring an unusual background, I think, to this position that makes me uniquely qualified to do it. I've been a practicing attorney for 16 years. The first 10 of those were practicing full-time civil litigation in law firms downtown. And I've handled cases and trials all throughout the state of Pennsylvania and in other jurisdictions as well. For the last 8 years, I've also pursued the career of being a teacher. And I've worked in all of our schools in the Fox Chapel Area School District. I'm well aware of all of the people and the concerns of each of our neighborhoods. And I've worked for the last 4 years in the Pittsburgh Public Schools, working with students who have faced enormous obstacles to achieve what they have, even to be in the middle school and high school, frankly. So, I've always been a public servant. I've served before being a teacher as a fireman for 15 years in Fox Chapel. It's in my blood, and I see this as a way to marry these two careers in a way that I think will be a real benefit to our community, and in particular will help to work to rehabilitate members of our society that come through our court system. Thank you.
Thank you. Mr. Rutsky?
Thank you to the League and to everyone watching, as well as to the other candidates participating. I am Matt Rutsky, and I am running for magistrate. I have been practicing law in Aspinwall since 2013 at a community-based firm. Prior to that, I clerked at a firm in Sharpsburg and interned in the district attorney's office. I've also served on the panel of the County Board of Arbitrators. In addition to that, I currently serve as the mayor of Sharpsburg. Before that, I served on council. In all of my experiences as a local practicing attorney and as a mayor, I've learned how to meaningfully and effectively serve my neighbors. And I want to take my collective experiences of being boots on the ground and finger on the pulse, and I've learned what works and what doesn't work. And I want to take that common sense approach so that I can go from helping the 3,300 residents of my hometown to the 30,000 residents of the school district.
Thank you. The next question, Mr. Turner, you will answer this first. Have you volunteered your time for community service, and how could this experience impact you as a judge?
Sure. Thank you. I've volunteered a lot of my time for community service. Beginning at age 14, I was a volunteer fireman in Fox Chapel and did that until I was about 31 years old. I've volunteered as a community coach. I've volunteered to serve as an attorney, helping victims of abuse obtain protection from abuse orders, to help parents who can't afford to hire attorneys to handle custody disputes over their children. I've spent a lot of time in my life volunteering, and the service no doubt informs me job of being a magistrate is really a community job. It's local in nature, and it's local for a reason, because we need to know our communities. We need to know the needs and concerns of all the community members around. But also, the value of service is something that can assist people as they're trying to return to society, as they're trying to earn their trust back with the community if they've committed some sort of crime. So, I believe very much in the power of service and in the power that service can provide as a healing mechanism as well.
Thank you. Mr. Rutsky?
Thank you. And community service is vital to all communities. It's how people show that they are invested in their neighbors, invested in the places, and invested in outcomes. And in my time as a mayor and as a council person, and even before that, I've been serving on multiple boards and multiple committees, nonprofit organizations, the Allegheny River Towns Enterprise Zone, the Fox Chapel District Association, the Sharpsburg Historical Commission, the Second Harvest Campaign Committee, as well as the Sharpsburg Neighborhood Organization. And in all of those roles, I have learned how to serve my neighbors. I've learned what matters to them, and I've learned what's important to them. And I want to bring all of those hours of serving my neighbors and serving my community and those experiences to the bench with me, because it is important to apply what we have learned to the people around us so that we can improve outcomes for everyone.
Thank you. Ms. Ivanovic?
Yes, I have been a volunteer pretty much my entire life as well. I volunteered in high school. I was in the Key Club, and in college, I volunteered at a shelter for homeless families. Currently, I volunteer with Aspinwall Neighbors. I deliver soup to the elderly residents in our community. I actually created and organized an annual fundraiser that's been going on for 10 years called Spin Your Wheels, and we raise money for therapeutic horseback riding for children with special needs. And I'm also on the board of directors of Open Up Pittsburgh, which provides accessible yoga in schools locally. I do pro bono work through my legal practice. I've done clean slate and expungement clinics. And I also do pro bono work for individuals living with autism. And I've done first responder training with first responders and individuals with autism, teaching them, educating them on how to remain safe during encounters. And I think it's a great way to get to know your community and give back, and shared experiences lead to a better understanding of your community, which leads to being a more empathetic person. And that's an important characteristic for a magisterial district judge.
Thank you. And I just want to remind all the candidates, if you need me to repeat a question, just please ask, and I'm happy to do so. The next question, Mr. Rutsky, you will start with the answer first to this question. Magistrates work on a local level with fellow community members, family, and friends. How will you remain objective, and how would you handle conflicts of interest of those you know personally that will appear before you in your courtroom?
Thank you. It's a great question, because the appearance of impropriety can raise lots of questions, and magistrates are community-based judges. And there are situations where our neighbors will be appearing before us, or a family member could be charged with a crime. And I think there has to be two distinctions. So obviously there are instances where a judge should recuse themselves because it goes beyond that appearance of impropriety, whether it is a family member or someone who lives directly next door to you, or in the case of donors to a campaign, there are bright line rules that cannot be crossed. But then there are situations where we will encounter our neighbors because we are community-based judges. And in those situations, you advise the parties appearing before you of the possible conflict so that they are aware of it. And if they are comfortable or they don't have any objections, then you can hear that matter.
Thank you. Ms. Ivanovic, same question to you.
Thank you. I know that I can treat everyone equally and fairly in the courtroom, but as Mr. Rutsky said, you are a community-based judge, and chances are you're at some point going to know someone in some way, somehow, and there's going to be a question of a conflict. So what you have to assess is the closeness of that relationship and whether or not you can remain impartial. And that usually arises when there's a financial or business interest, or if it's a close friend or a family member. The Code of Judicial Conduct requires that a judge avoid all impropriety, and that includes the appearance of impropriety. So if there is any question to that or any doubt, you have to assess that and ultimately recuse yourself if you feel that that's being questioned. But you would first get the opinions of the parties involved in the case. And if everyone agrees that you can go forward on the case, then you would. It is costly and time consuming to recuse a case, but when it needs to be done, it needs to be done.
Thank you. Mr. Turner?
Well, I've said that, we will know people in our communities that appear before the magistrate judge. It's just a natural, inherent aspect of this position that we represent 6 neighborhoods that adjoin our neighborhoods or are our neighborhoods. So the candidates speak correctly when they say that there are bright line rules. I mean, family members to the 3rd degree that requires recusal. Financial interests, that requires recusal. Otherwise, if there's a concern that you have, or a concern that I would have, that it could be seen as a potential issue that I wouldn't be able to handle things fairly, even if I think that I can, the rules require us to disclose that to both parties and to allow the parties to raise their concerns to us. And again, recusal, meaning determining that it's not appropriate for you to hear the case, is the result. But the number one job that a judge does have is to hear cases. And so, sometimes that may mean making uncomfortable choices in an objective way, even if you know somebody that's before you.
Thank you. This next question, Ms. Avashovic, you will answer this first, please. Some feel that law enforcement may have an undue influence on our court system. How would you balance the court's relationship with law enforcement with the rights of the defendant?
Well, no one should feel that they're being treated differently because of who they are. The relationship between the court and law enforcement is a professional relationship. Law enforcement is often in the court building because they have a lot of business there. They're there filing charges, having warrants reviewed. They're there for arraignments, and they're there for their court appearances. So people may come in and may assume that the law enforcement officers have an upper hand, but that is not the case and should not ever be the case. A defendant has a right to know that everyone is on a level playing field and no special treatment would be given to anyone. There have to be clear lines and clear boundaries also within the courtroom. People need to know where they are allowed to go within the courtroom. The back of office is not a place for anyone to gather. I've had cases where my clients come in and see police officers in an area that the public is not allowed to be in, and they feel like they have an unfair advantage or disadvantage, I should say. And I would not want anyone coming into my courtroom feeling defeated before even a word is spoken in a courtroom. So there have to be boundaries and lines drawn and adhered to.
Thank you. Mr. Turner, the same question to you.
Could you repeat the question for me, please?
Sure. Some feel that law enforcement may have undue influence in our court system. How would you balance the court's relationship with law enforcement with the rights of the defendant?
I think that the answer is that I'm lucky to be a lawyer because I've had dealings with people who, as attorneys, who I like very much on the other side, or who I dislike for some reason or another. And the result is it really doesn't matter. And my point is, if a police officer comes in who I have some connection with and I'm comfortable with because I have dealt with them before to sign warrants, they are a witness. They have to prove their case. They have to come off as reliable and trustworthy and credible in their evidence. They have no advantage over a regular ordinary person. And so they should not feel that there's an imbalance of power. And, it would be my policy to explain that to unrepresented litigants as they walk into the door. Yes, the police are here. Yes, they're wearing uniforms, but they receive no preferential treatment in the hearing of evidence. And you have the right to be presumed innocence while we listen to the evidence that's being presented by the police.
Thank you. Mr. Rutsky?
Thank you. And to pick up from where Mr. Turner left off, everyone that comes into the courtroom is clothed in innocence. And, it's no secret that I was raised by a police officer. My father was a police chief in Sharpsburg, and I'm also the mayor of Sharpsburg, which puts me at the top of the totem pole in Sharpsburg as the leader of the police department. And so there are distinct situations where people may look at the magistrate's office and see police officers hanging out there for any length of time, and that might create the impression that the officers are hanging out or have some sort of undue influence on the court, and that needs to be avoided at all costs. as Ms. Vašević points out, if there is a part of the courtroom that no one should be entering other than the court staff, you should not be allowing the public or police officers back there, because we need to create these boundaries. And boundaries are important so that no one believes the judge is taking one side or the other. Justice has to be balanced, it has to be blind, and you cannot let any appearance of undue influence into the courtroom.
Thank you. The next question, Mr. Turner will answer first. Do magistrates have an obligation to do something about, or at least publicly say something about, abuse they see being committed by law enforcement who appear before them?
I have a simple answer for that. Yes, if there's some sort of abuse that appears before them. I mean, the first number I'm calling is 911. As a citizen, I'm making sure that everybody is safe in my courtroom. And if some police officer is committing abuse in the courtroom or abuse that I see in the community, then I'm fulfilling my obligation as a citizen first. But of course, if I'm aware or it's reported that that there was police brutality, then that needs to be reported to the appropriate authorities, and that needs to be investigated. And if appropriate, although it's outside of my would be outside of my responsibilities, to be prosecuted and investigated if appropriate.
Thank you. Mr. Rutsky?
The answer is yes. If a police officer is doing something that's inappropriate, whether it be a crime or anything related to the course of their job, it needs to be reported, whether that be up the chain of command to the police chief or to the mayor, or if nothing is being done there, it can be referred to the county police. And also we have to keep in mind that police officers are certified by the state through Mobitech. So if an officer is doing something that is not befitting of the role that they play, it should definitely be reported, because that upholds the confidence in their job, but it also upholds the confidence in the courts. And that's something that MDJs or any judge has a duty to protect, because we do have to maintain that appearance of being an impartial arbiter. And if judges aren't playing that role of reporting something they see happening before them that is inappropriate, then that confidence is going to break down. So if there's any sort of impropriety being taken by a police officer, yes, it would be reported to the appropriate authorities.
Thank you. Ms. Vašević?
Yes, the short answer is yes. Police officers don't get to live by different rules than anyone else. If there is some sort of abuse going on that I'm witnessing, that would be reported to the authorities just as if it would be anyone else that comes into the courtroom. And that would, the district attorney has an investigative unit, the county police has an investigative unit. I'm not there, obviously, to judge it unless there are charges filed, but the reporting of something that I would witness would happen across the board, whether or that is a police officer or a layperson from the community. It's important to be consistent and follow the laws.
Thank you. This next question will go to Mr. Rutsky first. Persons coming into magisterial court may be seeking resolution of a landlord-tenant dispute, may be seeking emergency relief for protection from abuse, may be facing arrest, or seeking a resolution of a money claim. As a result, they may be under considerable stress and facing uncertainty. What are the skills and the professional and personal characteristics that you possess that show you have the judicial temperament to assure all persons appearing before the court are treated with dignity and respect and fully understand how the court will carry out the proceedings? I'm sorry, that's a little long. I will repeat it if necessary.
No, thank you. That's a multifaceted question, and I will do my best to address all of it. But as a mayor, I often tell people you sort of take on the role of a social worker, and I have been solving lots of community-based problems, literally and figuratively, from my doorstep. In that time, it's you're solving these issues for people who are coming from all different walks of life, different socioeconomic backgrounds, different demographics, and they all have to be treated in the same way. And that's getting people the help that they need and the help that they deserve. And it's the same in my practice as a lawyer. We're dealing with a local-based firm. We get people walking in, or we get people who are longtime clients, and they all expect the same thing. And that's that we solve their problems with dignity and respect. So if someone is coming into the courtroom, for example, and they could be unrepresented, and no matter the situation, there are referral services that you can use there to get them the help that they need, whether that's through neighborhood legal services or a referral to the public defender's office. And in these instances, you can continue cases for 30 days or 60 days so that that person can acquire the help that they need to be properly represented for the court. And that's how you can guarantee that someone gets that opportunity before the court that grants them that dignity and respect.
Thank you. Ms. Ivashevic?
I'm sorry, could you repeat the question? It was really long.
Sure. People will be coming in for resolution of landlord-tenant disputes, emergency relief from protection from abuse, facing arrest. As a result, they may be under considerable stress and facing uncertainty. So what are the skills and the professional and personal characteristics you possess that show that you have the judicial temperament to assure all persons appearing before your court are treated with dignity and respect and fully understand how the court will carry out the proceedings?
Okay, thank you. Well, court can be a stressful situation for anyone. Sometimes this is one of the worst days of someone's life when they're coming into the courtroom. So I would, as an attorney, I've had many clients that, can barely breathe. They're so nervous coming into the courtroom. So just being able to explain clearly and in regular language, not using legalese, so that people can understand what's going on, encouraging a lot of questions and being happy to answer them thoroughly is important. And I have to do that with my clients all the time. They're very nervous coming into court. I am also a mom of an 18-year-old son who has significant special needs, and life is stressful for him all the time. And he's taught me to be calm because I need to be for him. And I'm a mirror for him. So if I'm calm, then he's calm. And I think that is true for people in general. So if one person is calm and even-tempered, then it sets the tone for the whole room. And it will follow that everyone will also relax. So as long as you're speaking to people with respect and you understand that they are going to be stressed and nervous and these are tense situations, you can try to bring the stress level down in the courtroom.
Thank you. Mr. Turner?
Thank you. So I've mentioned that I'm a teacher, and the schools that I've taught in over the last several years have been filled with an unfortunately high population of students that have dealt with a great deal of trauma in their lives. That trauma can show up in any number of ways at any time when you least expect it, when something can just trigger a completely emotional response, an inappropriate response, and I've learned how to deal with that. And the way to deal with that is through evidence-based practices that includes being respectful, listening, not lecturing. Lecturing has been shown through evidence to have very little effect in changing people's behavior. And ultimately, what I'm interested in is A, the truth, and B, the ultimate success of the person and the people that are before our courts. As a teacher, I have a long-term vision of success. It's not just what happens that day in court. It's how people end up living their lives, hopefully successfully after they've come through the system. So people can rest assured that because I'm interested in their long-term success, I don't have any interest in being anything but respectful for them as they come in and we try to work through their problems.
Thank you. Ms. Ivashevic, you will answer this question first. Please describe a case or situation in a courtroom where you were involved in that you believe your temperament and patience was tested. How did you handle it, and did you learn anything from it?
Well, after handling about 50,000 cases, it's kind of hard sometimes to remember every case, but there are some that stick with you and you remember them forever. When I was a prosecutor, I had a case with a victim who it was a terrible case. He was 6 years old, and it was a very busy courtroom. And I had to meet him for the first time, interview him, and prep him for his hearing. And it's not easy to gain the trust of someone who is scared and has been traumatized, especially a child. And, you know, I took him into a room and we talked about literally everything: dinosaurs, cartoons, his dog. And we took a really long time. And knowing that I had a lot of people waiting for me outside of the courtroom, I was very busy. I had to be very patient and stay calm until he was ready to go. And, you know, he did it. He got up there and told his story, and he was brave. And, you know, the amount of patience that I needed to handle that situation isn't something that you can learn in a class or by reading an article. Because of that case and many like it, I feel that I am prepared to keep an even temperament, even in the most difficult of cases.
Thank you. Mr. Turner?
I recall working with a gentleman when I was volunteering at Neighborhood Legal Services, which provides free pro bono legal services to people who can't afford it. And this was an older gentleman, had difficulty hearing, came in and told me that he needed help because his electricity had been shut off. And it's funny, you know, this is not a huge complex case that happened in my life. I didn't have hundreds of litigants in it like some of the work that I've done has, but it was very impactful for me. I had to gain his trust through asking questions. Ultimately, it came out once we had the chance to relax a little bit in our conversations that he couldn't read. And the gentleman who lived in the apartment above him had helped him with all of his bills for a number of years. And this gentleman had passed away. And so, you know, it's an example of where patience was required to get to the ultimate underlying issue. Once we had that, we were able to deal with the utility company in a way that a result that would protect him as he moved forward. And ultimately, you know, that's a case from when I was a very young lawyer that sticks with me today.
Thank you. Mr. Rutsky?
Thank you. And temperament is the top quality of any judge or trier of fact that I have appeared before, along with patience and also empathy. I did have a situation in an administrative hearing where the trier of fact was asking questions of the witness, and the witness was trying to elicit a response about their due process rights from the trier of fact. And unfortunately, they weren't getting anywhere. The trier of fact was trying to push the matter along. And this goes to show that anybody appearing in a court or before an administrative body, they deserve the time from the court to have the rules explained to them in a clear and concise manner. And that really had an impact on me because, you know, you have to, in the role of a judge, be patient and be empathetic and have an even keel, because you could have people appearing before you who it's their worst day. And you have to look at the holistic approach. This is just a snapshot of time. They could be razzled. They could be at their wit's end, and you just need to work with them. You need to be compassionate, and you need to guide them through it. And as I said earlier, temperament is the #1 quality for any judge. And, you know, that's at the top of my list. And I would do my best to keep that even keel in all situations.
Thank you. Mr. Turner, the next question goes to you to answer first. How strictly do you believe the rules of evidence should be followed?
Well, you know, our rules that govern hearings in the district magistrates courts tell us that the rules of evidence are to be followed. And so, you know, it is the job of the judge to make sure that the rules are being followed as closely as possible. Now, there is some leeway afforded to judges in the instance of pro se clients, pro se litigants. And so, you know, it's not unusual in a situation with a pro se litigant that the court might help the pro se litigant comply with the rules of evidence. But despite that fact, the rules of evidence must be followed, and that's what our rules tell us. And without those safeguards in place, courts could be making decisions based on evidence that's unreliable or inappropriate for us to hear.
Thank you. Mr. Rutsky?
Thank you. It's important that we follow the rules to ensure that everyone is on the same playing field when they're coming into the court. It is important to bear in mind, though, that judges do have discretion. There are rules that could be a may or a shall. And as Mr. Turner points out, there could be situations where you have pro se litigants coming before you. And in those situations, as I referenced earlier, you can make referrals to them to neighborhood legal services or to the public defender's office, refer them to the PD's office so that they can get that legal representation that they require to ensure that the rules of evidence are being followed, and there's no situations where one party may be in a better position than another party, which would test or limit the bending of the rules by the judge.
Thank you. Ms. Ivashevik?
Thank you. Yes, the rules must be followed. They are there for a reason. With rules come responsibilities, and our responsibility as a judge is to follow those rules. And especially when there are two attorneys in your courtroom, they're expected to know the rules and to follow them. If you start to sway from that or go away from that, then you have a chance, an opportunity for someone to appeal or file motions, and it just becomes a big mess. So when there are attorneys, absolutely the rules must be followed. But as my colleagues have said, when there's a pro se, litigant, that anyone in the court without an attorney, you first want to make sure that they know their rights to have legal counsel and give them all of that information. I do believe that it can never hurt to give someone too much information, but you also want to have some understanding. We are humans. Sometimes they don't understand, if they're representing themselves, what the rules are. So without crossing a line and acting as their own attorney, because that would also be very wrong, you can explain things very clearly to someone about what the rules are and how to proceed with their case.
Thank you. This next question, Mr. Rutsky, you will answer first. Magistrate judges are authorized to set the terms of release and whether to set bail. The forms of bail authorized under Pennsylvania law include released on your own recognizance, cash bail, and in some cases, electronic monitoring. What factors will you consider in granting and setting bail amounts for defendants?
Thank you. I think we should first point out that the purpose of bail is to guarantee someone's appearance, and it should not be punitive in nature. There are 5 types of bail, including cash bail, and we know that there's a disproportionate impact that it has on individuals. So in these situations, we do have the rules of criminal procedure. We know what that outlines, but we also know that we need to look at the reasonableness of that cash bail that's being applied. There are individuals who cannot afford cash bail, and in those situations, unless you have to guarantee their appearance or they've committed a crime that requires them to be incarcerated, then you would not issue cash bail in those situations. I'm aware of the risk assessment tool, but we also know that that risk assessment tool is based upon systemic inequities in the system through prior convictions or prior arrests. So the scales are a little bit out of balance there. But fundamentally, again, to remind everyone, the purpose of bail is to guarantee someone's appearance and not be a punitive measure. I don't think it should be used in all situations, nor should it be taken lightly. And it's one thing that we have to address throughout the entire court system to make sure that nobody is being jailed simply because they can't afford to get out of jail. Because one night in jail can ruin someone's life. They can lose their job, lose custody of their children. It could cost them their home if they can't make their mortgage payments.
Thank you. Ms. Ivashevik?
Yes, first of all, no one should be in jail because they can't afford to get out. The purpose of bail is to ensure that someone will appear for their court appearances, and not to punish someone. And also you have to take the safety of the community into consideration. And the rules are very clear about the factors that you have to consider when assessing what type of bail to give to someone. Things like their ability to pay, or the nature of the crime that's alleged, or do they have any prior failure to appear warrants? So that is judging the likeliness that is this person going to appear in court. There can't be a blanket rule about what you're doing with bail, because you have to take everyone's unique circumstances into consideration. And there are many alternatives to monetary bail that can be used: drug and alcohol evaluations, no contact orders, electronic monitoring is available, but it is very rarely used because it ends up being very costly for a defendant. And if they can't afford a cash bail, then they're not going to be able to afford electronic monitoring. And I've participated in thousands of bail hearings on the prosecution side and the defense side. I know the arguments that can be made. I know what alternatives are out there to monetary bond. But I also know that some people will leave the jurisdiction if they don't have something to keep them here. So all of those factors have to be balanced when determining what type of bond to give, and I'm prepared to do that.
Thank you. Mr. Turner?
I think Ms. Savashvik hit the nail on the head when she said the rules are clear about what we're to follow. The rules tell us the exact considerations, and those mentioned, and the nature of the crime needs to be considered. The contacts that the defendant has in the area that would make them more likely to stay, the employment of the defendant, and there are numerous others. And yes, it's true about cash bail that there seems to be some disproportionate effect on people, but the rules tell us how to deal with that. And if we follow the rules, we're going to be absolutely fine using cash bail, because the rules require us to take into account the person's access to funds and their expenses. So it takes work on the part of the judge to find an amount that's appropriate, if cash bail is appropriate. But again, the rules require us to consider cash bail and other forms of assurances that that defendants will come back before the court. And it's our job to take all of those into consideration. So, you know, my guiding principle, it's the very first thing that the rules tell us magistrate judges to consider, and that is to follow the law. And that's exactly what I do.
Thank you. Ms. Savashvik, you'll get this next question first. What is the standard of proof that must be reached in magisterial court to bind a person over for trial in common pleas criminal court?
Okay, so if a case can't be resolved at the magistrate level, then you will have a hearing. And the standard of proof is called prima facie. And that literally means, I think, at first look. And what it in reality means is that more likely than not, this person committed the crimes that are charged, more likely than not. So it's a very low burden of proof. But I have, in my experience, seen plenty of cases be dismissed at magisterial court, district courts, because the evidence just wasn't there, and the Commonwealth couldn't meet their burden. So sometimes magistrates have to make difficult decisions on difficult, unpleasant cases if the evidence isn't there. But that is the burden of proof. It's the prima facie, it's called.
Thank you. Mr. Turner?
Yeah, I can only echo that it's more likely than not that the defendant committed the crime. It is a low burden. That does not mean that it's appropriate for a magistrate to rubber stamp that the Commonwealth has met its burden. So it's still our obligation to require challenge of the evidence that's brought before us, and to critically look at it and make sure that each element of the crime has had that appropriate level of evidence brought before it, so we can say, indeed, the Commonwealth has met its burden, and it's more likely than not that the defendant committed the crime.
Thank you. Mr. Rutsky?
Thank you. I also think, in addition to what has been pointed out, the purpose of a preliminary hearing is to protect an individual against an unlawful arrest or detention. It is a prima facie standard. has a crime been committed and the defendant commit the crime. And that burden has to be carried by the Commonwealth, although it is a low burden. But due process does attach. Preliminary hearings are very, very important and vital for that reason. Again, to prevent unlawful arrest or detentions.
Thank you. The next question will go to Mr. Turner first. Drugs and alcohol continue to affect our communities and our schools. What are we doing right to address these issues? What are we doing wrong? What reforms, if any, do you think are needed?
Well, I see it all the time. I see it in the schools that I've taught in, unfortunately. And I've seen students, young men and women, who feel like they can't even get to school without the use of drugs or alcohol. And so, what we're doing right as a community is we're practicing therapeutic jurisdiction as a legal community. Pardon me. We're practicing therapeutic jurisdiction. We're trying to find alternative ways to get defendants who can show that their conduct is based on a dependency on some sort of chemical, the help that they need. And if they can satisfy the requirements of the court that they've tried and in fact have addressed those issues, then they're able to move forward with their lives. And I think that that's an appropriate goal, again, with the idea that part of what the legal system is for is the long-term success of people that come before the court. What we're doing wrong, a lot of times we're not looking for that, I don't think, or we're saying, oh, somebody's a drunk and therefore they're just a vice in society. There's still real stigma attached to dependency, and it's something I think we need to work through as a society.
Thank you. Same question to you, Mr. Rutsky.
Sure, thank you. And it's about education and ending that stigma. Unfortunately, especially since the pandemic started, we have seen a drastic increase in overdoses and overdose deaths here in Allegheny County and across the country. And it's unfortunate because the thing about addiction is it's a disease. It doesn't matter where you come from or who you are or your demographics or how wealthy you are. It impacts all of us, and it impacts the family members and friends around those individuals too. I'm proud to say that in my time in Sharpsburg as mayor, I've regularly hosted Narcan clinics in the community. And the point of those clinics is to get Narcan into the hands of as many people as possible. Because if we can save one life, that's one life saved for all of their family members and their friends. And, we can rehabilitate people through diversionary services to make them, productive citizens again. We've also recently joined law enforcement assisted diversion. And these are for individuals who may have a drug charge, whether it's possession or if they have alcohol related problems. And we can get that person hooked up with a social worker and put them into programming or counseling so that they can get back on track, because we can't leave anyone behind. Everyone needs to be cared for. Everyone needs to be taken care of. We need to show more empathy because every life matters. And, these things are meaningful to me. And that's why I do the Narcan clinics, or, I support the law enforcement assisted diversion programs.
Thank you. Ms. Ivashevic?
Could you repeat the question, please?
Sure.
Thank you.
Drugs and alcohol continue to affect our communities and our schools. What are we doing right to address these issues? What are we doing wrong? What reforms, if any, do you think are needed?
Okay, what I think we're doing wrong when in the situation is ignoring a problem. Now that's getting much better, but there are people who say there's no problems in our school district. It's fine. And I don't think that's the right attitude to have, because substance abuse problems don't discriminate. They can attack anyone, anywhere. And another thing is automatically jailing someone or detaining someone who has a substance abuse problem. And what I think we're doing right is raising awareness in the communities and in the schools. I know we have our local officers that do programming in the schools. I think that is excellent. Education for people is important. And access to treatment is another problem that we're working on. But I've worked tirelessly as a defense attorney to help people and get them into substance abuse programs and work with them in comprehensive programs in the communities so that they can get the help that they need. And I think it's important to have the awareness and accessibility for everyone despite financial status as well. So those programs need to be explored.
Thank you. This next question, Mr. Rudsky, you will answer first. Since a magisterial judge deals specifically with truancy cases, how do you plan to support both the school's needs and the needs of the students who may not regularly attend school?
Thank you. It's an important question. We know that truancy, again, since the pandemic has started, it seemed to make a lot of problems worse, and truancy is one of them, especially with the remote learning. But I did teach for a year between undergrad and law school. I taught on a fellowship in 2 high schools. I taught English in Austria. And during that time, I learned there's a direct correlation between academic success and being in the classroom. I went through the Fox Chapel area school district system. I'm a Fox Chapel high school grad. So I've learned what works for our communities. And there are situations that students can be put into where they're not skipping just to skip. There could be problems at home, or there could be problems with bullying in the school, and those need to be addressed. The high school administration does, or the school district administration does a good job working with parents. They send out letters if they see a problem forming. They sit down with the teacher, with the student, with administrators, and try to resolve it. But if it remains habitual, then charges are filed. But I think in those situations, you sit down with the student if they're appearing before you, and I would have these hearings in the evenings. I wish to do an evening court for kids so that they don't have to be taken out of the classroom. And you work with them, you work with the parent, you implore upon them the importance of being in the classroom and becoming a lifelong learner. And if you can continue the matter for 60 or 90 days, if the problem abates, then the problem is resolved and it works, and you can use follow-up scenarios to make sure that they continue to go to the classroom.
Thank you. Okay, Ms. Ivashevic?
Thank you. I want to see every student attending school and graduating. Chronic truancy most often stems from issues from the home. So maybe they have a lack of reliable transportation, or they are taking care of a younger sibling, or maybe it's a deeper issue like a mental health concern. Judge Lang created a truancy program that she would hold truancy hearings 1 time a month in the schools during the school day. And I would maintain that program because it is effective, and the schools also support it. First of all, it gets the student into the school for the day. Second, the hearings are held first thing in the morning. So they're out a short period of time from the classroom, but then put back in for the rest of the day into their regular schedule. And third, for economic reasons, the school officials and counselors all take part of these hearings, and they are there already for the school day. And that would alleviate having to try to get approval from their respective unions or the school board in order to get approval for overtime hours approved. So I think it's important to work closely with the schools and the families and cooperate and come up with a comprehensive program to get to the root of a problem and try to solve those problems so that everyone is successful and the student is back in the classroom and can graduate on track. And the root problems have been taken care of as well. And the charges would be dismissed.
Thank you. Mr. Turner?
Thank you. So, I must say that this is right up my aisle of concern. The schools that I teach in, sometimes the chronic truancy rate gets into the 40s. Okay, and chronic truancy, I think, is defined as more than 12 absences in a school year. The question says, what do we do to address the different interests of the students in the schools? The interests are the same. The interests are the same. It's a bit of a misnomer in the question. Students need to be in school. Students need to be in school to succeed. The #1 indicator of graduation is attendance. And The opposite side is the number one indicator of a failure of success in school is attendance. These need to be at the school. There's no doubt about it. This needs to be convenient for the students. The students need, I think it's very beneficial for them to see the judge is in their place. There's no home court for the student. The judge is coming there. You're not going to be able to hide from it. We need to discuss these issues, and it's not going to work just to stay away. But all that said, what has been said is true. Oftentimes the issue is something from the parents. And so, it's of great benefit to get everybody together in one room with the administrators and the teachers and hash out a plan to give the student one more chance to succeed before any kind of fines result.
Thank you. This next question, Ms. Ivashevic, you will answer first, please.
Okay.
What is your experience in working with pretrial and diversionary programs? Do you support alternative sentencing programs? Why or why not?
Yes, I do. My first assignment in the district attorney's office was to work in the drug court program. And I saw the impact that made on people and the success of that program. But the issue with diversionary programs at the common pleas court level is that someone has to plead guilty to their charges first. So we can receive the same results using diversionary programs or alternative resolutions at the magistrate level. And this is something that I have been doing for 2 decades. What many people may not realize is that these are things that are already being done. This is what I do. I have resolved many cases when it was appropriate with alternative resolutions such as drug and alcohol counseling, comprehensive family planning and counseling, mental health evaluations and treatment, anger management classes. These are done and they're very successful when they're done right. And I would absolutely support that when it is appropriate. Now, it's not always appropriate, but that's a determination that the attorneys and the magistrate must make together.
Thank you. Mr. Turner?
I believe that we should be trying to do whatever we can to make imprisonment the last resort. And I agree that there are times where it's what's appropriate. But, another example, just talking about the truancy cases, there are instances where parents, for whatever reason, lack the ability or the time or the effort or whatever it is, the resources to parent in a way that we would deem acceptable to get them to school. Okay, so, parenting classes would be another example of a kind of resource that we would want to use in an instance like that to see if we can avoid the need for punishments and imprisonment. So, I believe in alternative sentencing. I believe that people should have a chance when it's appropriate and when there's some recognition of responsibility by the defendant to allow them the chance to prevent them from going into imprisonment.
Thank you. Mr. Rutsky?
Thank you. Yes, I do support diversionary services. When I did intern in the district attorney's office, I was in ARD for a while. So there I learned the importance of having these diversionary tools so that people can get out. They're charged with a crime but never convicted. They complete their program. If they complete it successfully, then those charges are expunged. So that person can get back on track. And that leads me to restorative justice. If people have unmet mental health needs, or they suffer from addiction, or there are kids at risk of truancy or delinquency, we need to pull them back from the ledge. We need to get them the tools and resources they need to get back on track. And as I referenced earlier with law enforcement assisted diversion, I'm proud that our department participates in that. And we are doing this at a local level already. So, for example, if our officers charge someone with a low-level nonviolent offense, they will get connected with a social worker and for referrals or counseling to keep them out of the criminal justice system. And the magistrate hearing can be continued for 60 or 90 days. If that individual completes their program and they don't reoffend, then those charges can either be reduced or dismissed or withdrawn so that we can get people back on track, because that's important. As Ms. Ivashevic and Mr. Turner pointed out, we want to avoid sending people to jail, and we want to break that prison pipeline. So it's very important to me.
Thank you. This will be the last question before we move on to closing statements. Mr. Turner, you will be the first to answer this question. The racial justice movement was amplified by the murder of George Floyd and has brought to the forefront the injustice in our justice system. How will you work to ensure that our justice system is fair and equitable to people of all races, ethnicities, and genders who will appear in your courtroom?
Well, I feel very fortunate in this regard to work in a very diverse school district. You know, the students that I teach, again, I have their concern at heart. It doesn't matter who they are. I take every student that comes into my classroom as an individual, and I try to make them grow, regardless of anything. And the wonderful thing is, at first, you don't know anything about them. You know, you're starting to plan before you even have any idea who they are at the beginning of the school year. So that said, given the diversity of the students I've worked with, given that I've taught African-American literature to high school seniors at a school with 80+% African-American and mixed race students, I'm aware of many of the concerns that are out there. And I think that the only way we can deal with it is to try to be cognizant of the fact that that people do have concerns about us as authority figures, to be aware of the fact that we do bring our own background with us, and to do our best to treat each individual as an individual, apply the law to them individually based on their facts and the facts alone, and not take their background into consideration at all when we make those judgments.
Thank you. Mr. Rutsky?
Thank you. I think we need to recognize that we all have these inherent implicit biases, and these exist because our brain creates shortcuts, and it's a way for us to get from point A to B very quickly. And what that has done, for one reason or another, has created some systemic inequities in our system. And the statistics are there. We do not need to rehash these statistics, but we know that the criminal justice system disproportionately impacts people of color in our community. And the role of the justice system there is to take a step back and look at the reasons why. Implicit bias training is vital. We've done it within our police department. I've taken a continuing legal education training on implicit bias, and I think it's something that should be required within the court system so that we can get to the root of the problem and uproot that weed that is amongst us, so that everyone is getting equitable treatment under the law. It's vital. We all come from different backgrounds. Our communities are diverse. Sharpsburg is a very diverse community. And, we need to address these issues. And it's important, again, to make sure that people have confidence in the courts. And that is paramount. We need to amplify voices and listen so that everyone has a fair opportunity, an equitable opportunity when they're appearing before a judge.
Thank you. Ms. Ivashevic?
Thank you. Yes, we live in probably one of the most diverse communities, school districts, probably in the state. But everyone should be treated fairly and equally when they come into a courtroom, and no one should walk in there feeling that they won't be treated fairly because of who they are or what they look like. We know that the justice system disproportionately affects people of certain races. We know that people of color receive sentences that are harsher than people who are white. Being aware of these inequities and biases are just the first step in trying to correct these inequities. And the self-reflection is also important. I'm a woman of mixed race, and I've experienced bullying, and my children and I have been called slurs. And as a woman, I've been harassed. We shouldn't be treated any differently because of our heritage. No one should. And understanding the inequities that exist and feeling it in my own way make me more vigilant and compassionate and empathetic. And I think that's important. And I would work tirelessly to maintain a courtroom that was free from bias and discrimination. And the law will be applied equally to everyone based on the facts. And that's just the way it is to try to be as fair as possible.
Thank you. We will now move on to closing statements. Mr. Rutsky, you will go first with your closing statement, and we'll move back up to Dave, and Dave, Mr. Turner, and then Ms. Ivashevic.
Thank you again to the League and to everyone watching, as well as to the other candidates for your time with this forum. People have already started voting. There are people who are in the process of voting, and there are individuals who are going to vote on November 2nd. I am asking you to take into consideration my 10 years of elected public service, solving community-based issues, my 8 years since 2013 practicing law in Aspinwall, solving my neighbors' problems, resolving disputes between neighbors, my time clerking at a firm in Sharpsburg and interning in the district attorney's office. I've got deep roots in this community. I was born and raised here. I went through the public school system here, and I want to take all of my collective experiences and apply those to the bench, take that common sense approach to the bench, coupled with my legal training. I humbly ask for your vote on November 2nd to deliver that to everyone in our community so that I can go from serving the 3,300 residents of my hometown to the 30,000 residents of our school district. Thank you.
Thank you. Mr. Turner, your closing statement.
One thing that I've learned from working with hundreds of students, again, many who've been through trauma and show inappropriate and difficult behaviors, is that to change their behavior, it takes time. It's not, you're very lucky if one punishment somehow corrects behavior that's built into somebody's system. And so what I'm proposing as a full-time magistrate is that when I'm not hearing cases, I'll be following up with people who've come through the court system, trying to help them re-enter into society, trying to help them recover from their issues, trying to problem solve with them, and to keep them holding themselves to account. Because what I've found is you can find incredible changes in behavior from people you least expect to happen when they buy into the fact that the system is there to actually help them and not hurt them. Now, we've all said we're going to be full-time magistrates. I don't know what the other candidates are going to do during the time when they're not hearing cases. We could all be full-time magistrates and do the same amount of work we would have if we were part-time magistrates. You know what I'll be doing. I'm putting a plan together. You can find it on my website. It's Elect Dave Turner. And it's meant to close the gap in our local community system because we don't do anything to prevent second offenses and rehabilitate our citizens to help them reach their full potential after coming through the court system. Thanks for your consideration.
Thank you. Ms. Ivashevic, your closing statement, please.
Sorry. Thank you to the League for hosting this forum today. I am the only candidate that has decades of firsthand practical experience in a magisterial district court. My experience as a prosecutor and a defense attorney have prepared me to handle any type of case that comes into these through these doors, and it makes me uniquely qualified for this position. I have spent my entire career helping people on a local level, and I hope to retire, continuing to help the residents of our community. And that's why I have no intention of seeking a higher judicial position or another political opportunity. I'm not embedded in politics. I never have been. I never sought endorsements from a political party or politicians, but I am unanimously endorsed by the Joint Labor Council, and they know that I work tirelessly for the families of workers in our district. And I truly believe in people over politics. I'm also endorsed by Judge Lang, who this community trusted to keep in office for 17 years. And she has seen my work firsthand and knows that I have what it takes for this job. I'm dedicated not only to my home community of Aspinwall, but to all 6 communities in our district. And finally, I am a mixed race woman running, a highly qualified woman running for this office. And I represent the diversity of our community. So experience matters, representation matters, and an independent voice matters. Thank you.
Thank you. And on behalf of the League of Women Voters of Greater Pittsburgh, I'd like to thank all of our candidates for participating. And I'd like to thank you, the viewers, for your interest in this important race. Voters can obtain more election information on our website, lwvpgh.org. There you will find other judicial candidate information for statewide appellate courts and the Allegheny County Court of Common Pleas. I'd also like to remind voters and viewers who are watching that you can obtain information about all the candidates that will appear on your specific ballot by going to vote411.org and entering your address. Deadline for registering or changing your address has passed, unfortunately, but the deadline for applying for a mail-in or absentee ballot is October 26th. Please remember to vote by mail or in person on Election Day, Tuesday, November 2nd, from 7 a.m. to 8 p.m. This recording is the property of the League of Women Voters of Greater Pittsburgh and can be found in its entirety on the League's Facebook and YouTube pages. The public may share this recording. Thank you for your interest in these candidates running for this important office. Good night.